In this episode, we talk about why a murder case dating back 3 years has now come back to haunt the BJP in Uttarakhand. We also discuss the second phase of the ongoing special intensive revision being conducted by the Election Commission of India and what its latest data reveals. But we begin today by discussing the Supreme Court's verdict regarding the accused in the 2020 Northeast Delhi riots case. Hi, I am Niharika Nanda, and you are listening to Three Things, the Indian Express news show. On Monday, the Apex Court granted bail to 5 of the 7 accused in the 2020 Northeast Delhi riots, a case in which 53 people were killed and several others were injured. These individuals, the prosecution claims, are key conspirators, and they were arrested more than 5 years ago. But the court, however, did not grant bail to 2 of these people. The former JNU student leader Umar Khalid and activist Sharjeel Imam, saying that the accused in the case do not stand on equal footing. To unpack the court's reasoning and how this order expands the definition of terrorism, my colleague Shashank Bhargav speaks to the Indian Express's national legal editor Apurva Vishwanath.
Apurva, in the Delhi riots case, of course, there are cases related to the actual rioting that took place on the ground. And then there are cases related to what the Delhi police says was a larger conspiracy to orchestrate these riots. And that's what the case against these 7 people who had approached the Supreme Court, including Umar Khalid and Sharjeel Imam, relates to. Now, these people had been in jail for over 5 years, with their bails being denied multiple times. Could you remind our listeners what evidence does the prosecution have against them?
So this larger conspiracy case that the Delhi police has filed against these accused, this is a terror case. So this is under Section 16, read with Section 15 of the Unlawful Activities Prevention Act, which is what penalizes a terrorist offense, right? So how does the police go about building this case? They basically stitch together, say, WhatsApp messages, calls for protests, public speeches, and so-called secret meetings. And they have witnesses who are protected witnesses, which means you don't know their identity. And they are identified as, say, Pluto, Neptune, Romeo, Juliet, and a bunch of these names. So like a chain of so-called evidence is what the Delhi police says they have to build this larger conspiracy case. So their case is that over days, in preparation to the communal riots, a bunch of these individuals planned to conspire terrorist acts, right? So the issue here is it lumps everything from a rightful protest, a chakka jam, creation of a WhatsApp group, to, say, the actual communal violence that happened somewhere else, which was not participated by these individuals.
Now, the crucial thing in this case is that it has been 5 years and the trial has not even begun. But despite that delay, these people had not been able to secure bail. But this week, the Supreme Court granted bail to 5 people: Gulfisha Fatima, Miran Haider, Shifa Rahman, Mohammad Salim Khan, and Shadab Ahmed. They have all been accused of conspiring to have these riots. But the Supreme Court did not grant bail to Umar Khalid and Sharjeel Imam, even though they have been charged under the same section. Tell us, why did the court do that?
So, in a sense, the prosecution's narrative in this larger conspiracy has centered around Umar Khalid and Sharjeel Imam. So you've seen words thrown around in court like masterminds, so-called conspirators, or key conspirators. And in fact, even the charge sheet against Umar Khalid starts with this line saying, Umar Khalid, a veteran of sedition. And this is somebody in their 30s. So the prosecution's narrative has always been that these were the key conspirators. What we need to note here is actually Umar is only an accused in this larger conspiracy case. There isn't any other criminal case against him.
Right, also because he wasn't there in the city when the riots took place.
Right, but even otherwise, right, like Arms Act, any witness saying something against him, he is not named or wanted in another FIR at all. So this is the only case against him. In fact, during the course of the hearing, the state actually played out videos of Sharjeel Imam in court, right? So this was on the screens in the Supreme Court. The judges watched this controversial speech by Sharjeel Imam in which he talks about the chicken neck and, So the prosecution's focus, in a sense, has always been on these two individuals. Having said that, all the 7 accused who moved for bail before the Supreme Court, they're all charged under the same sections. So in terms of what they're accused of, the offenses, there is no dissimilarity. But yeah, like you can say that the prosecution's thrust or their focus was on these two individuals. And the Supreme Court accepts that without questioning the evidence that is presented to the court. We'll come to why later, but the Supreme Court accepts this prosecution's narrative and then says, okay, there is a hierarchy of offenders. These two individuals, Umar and Sharjeel, they are at a higher footing because they planned it, they created this conspiracy, whereas the others, their role is on a lesser footing, so to say. They only facilitated it and participated in the conspiracy. So, in some sense, they can be allowed this leniency of bail, but not these two individuals.
And has it ever done that before, made these hierarchies in a terror case?
Look, in a regular criminal case, right, the court does look at varying degrees of participation. Like, for example, let's take a murder case, right? You bought me the murder weapon, but I actually stabbed that person, right? So there is a difference in your level of participation versus mine. But what happens in this case is that ordinary criminal law idea is taken and, in a sense, weaponized to a different level because this is a case of conspiracy, right? And a conspiracy is basically where there has to be a meeting of minds. You and I have to agree to do the same thing at the same time. So there can't be a lesser conspiracy and more conspiracy in that sense, right? If you are conspiring to create terror and I am not conspiring to create terror with you, then we don't have a conspiracy. I mean, that's logic and that's, in a sense, common sense. So in a case of this nature, where the evidence is flimsy and entirely circumstantial and kind of really has to be strenuously pieced together to make a coherent case, the court, without examining this on the strength of the evidence, just accepting the prosecution narrative and saying that there is a hierarchy is logic turned on its head.
And you mentioned that the court didn't go into the merits of the evidence at hand. Is that because in terror cases, we don't do that at the bail stage? It only happens once the trial begins?
Yeah, so unfortunately, for the last few years, the Supreme Court has sort of shut itself, like legal scholar Gautam Bhatia says, the court has its eyes wide shut when it comes to UAPA. The court is completely unwilling to look at any evidence on the record, right? So for example, there is a witness who says, this is a protected witness, who says he was delivering food in a place in Northeast Delhi. And in the basement, he heard Umar Khalid hatch this conspiracy, right? Now, any court would look at the strength of that evidence. I mean, I'm just giving you one example out of the hundreds of such things in that charge sheet. But in UAPA, the court says it will not look at any of it. So every time the accused tries to challenge the nature of the evidence, the court says, look, this is not a mini trial. But every time the court has to accept the prosecution's narrative, they are happy to go into this hierarchy of offenses and grading on the basis of participation. So and this is problematic because it's also not uniformly applied, because there are cases where the Supreme Court is granting bail, but there are cases where the Supreme Court says, our hands are completely off when it comes to UAPA.
So does it essentially depend on which judge is looking at the case?
Yeah, unfortunately. And, Umar's case was not even built, like the foundation of his plea in court is not even, look at the material evidence and find that there is nothing. This case was almost entirely argued. There were other arguments, of course, but it was mainly argued that these guys have spent more than 5 years in jail. So even if there is evidence, even if there is a trial that has to go through, this pre-trial detention of these individuals is unfair and constitutionally impermissible. So here's the troubling part. The court says that, yes, they have spent a significant amount of time in jail, but the gravity of evidence against them seems to suggest that they still haven't crossed that constitutional threshold. So, which means the court then has to look at what is that evidence, right? But that they are unwilling to do. So that is a problem. And yeah, you're right. It depends on the judge. Because we reported that in the last 9 years, that is from 2016 to 2025, the Supreme Court has granted bail in about 16 cases, which are cases under the UAPA, which are essentially terror cases, on the grounds that the accused had remained in jail for long periods and the trial had not even moved forward in any meaningful way. Which means the exact same plea that Umar, Khalid and Sharjeel, Imam and the other accused took, the court allowed it for 16 other accused, right? But these are different benches, different judges. So I guess in a sense, you can also pick your precedent and decide whether delay is a ground where you can grant bail, or say that the offense is so serious that we can't grant bail even if there is a delay.
And Apurva, the other thing you write is that with this order, the Supreme Court has now broadened the definition of what counts as terror. Tell us in what way it does that.
Yeah, so this is a very significant aspect of this larger conspiracy case, right? And let's just go back a step. There is a Supreme Court ruling called Zahur Ahmad Shawat Ali judgment, which basically says that in UAPA cases, you have to prima facie accept the prosecution's theory without questions, not look at any material at the bail stage. So basically, the court says we are going to tie our hands at our back and not look at anything. And this is a Supreme Court ruling and a very literal reading of the Section 45D provision of bail in UAPA. So one way high courts have tried to sidestep this, because essentially the high courts have to follow what the Supreme Court says, right? So in cases where the high courts had to grant bail, one way in which they did this was by saying, fair enough, we will take the prosecution's theory at face value, but we will have to first examine whether the offense which the prosecution is saying is a terror case, does that fall under the definition of terror? That's the preliminary question. If it falls under the definition of terror, fair, we'll take their case. But what if that is not at all terror, right? So in the Delhi riots case, one of the first bail orders which came for Devangna Kalita, Asif Iqbal Tanha and Natasha Narwal, a Delhi High Court bench of Justices Siddharth Mridul and Anup Bhambani said, oh, look, these are ordinary criminal acts. So what we are talking about, inflammatory speeches, instigation, rioting, arson, whatever you want to put in that conspiracy, right? There are ordinary criminal laws which can punish these. These don't need to be elevated to the terror tag, because the definition of a terrorist act is that you incite violence through certain means. And those means are, you use bombs, dynamites, powerful explosives. They are quite serious offenses. In this case, their means are, the prosecution's theory is that Umar Khalid's means were road blockades and chakka jams. So they don't really fall under the same category as bombs and explosives. So this is not really terror. So that's what the courts used to grant bail in those first set of bail orders, right?
Yeah, and that seems very logical. It seems very commonsensical, right?
Yes. So, but what the state did was immediately go to the Supreme Court and said, look, these three can be out on bail, because, the Delhi High Court orders were very detailed. So for a Supreme Court to just stay them or overrule them would have been very difficult. So the state says, okay, look, these three can be out on bail, but make sure this is not applied as a precedent in any other case, which is a complete dilution of process. That's not how an appeal should work. But the court at that time, for some reason, agreed and said, okay, this will not be a precedent. So now the key question again becomes, is what the state accusing these people of, does that fall under the definition of terror or not, right? And here it becomes important what this definition of terror is, because it clearly says a terrorist act is an act done with intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with intent to strike terror in the people or any section of people in India. Then the provision says this is done by use of quote-unquote bombs, dynamite or other explosive substances or inflammable substances or firearms or any other means, right? So what Umar Khalid's lawyers have, or any of the other accused in this case are arguing is, when you put bombs, dynamite, other explosive substances, inflammable substances, firearms, and then say ... or any other means, that ... or any other means must belong to the same category. That can't be a new whole other category of unconventional means. Like say, we're talking about bombs and suddenly we're talking about chakka jam.
Right, and this phrasing is also there because, you don't know what things can be used in the future. For example, now a nerve gas will fit into this category.
Absolutely. Or like a use of a nuclear weapon or something like that, right? Like we are talking about a category of likes. And this is also a legislative interpretation tool. So the court had to look at this definition and say, okay, is that what the legislative intent is? But again, the problem is this is not a constitutional challenge to the provision, right? This is a bail hearing. So in a sense, what's before the court is to either interpret the section in a way that gives liberty to some of the accused who are still accused and not proven guilty, right? Or interpret it in a way that gives the prosecution the benefit of doubt, right? And the court went with the prosecution's theory. And why does it say so? It's a very one-line explanation for the court. Says the parliament has said any other means, and if we leave out this unconventional, non-conventional means, then we will basically be rendering that section OTOs or rendering that phrase any other means futile. So let's accept the prosecution's argument here. So in that sense, what the court is doing is any other means can literally mean any other means, right? So let's say a speech, something that's been written, or anything can basically that your imagination can conjure can be any other means.
Right, and when we talk about chakka jam, by that rationale, the farmers' protests, for example, they involved blocking highways. So those could also be interpreted as other means.
Yeah, by this definition, possibly, right? Like any other means is literally anything that your imagination can conjure up. So is that what the legislation intended? To bring like basically everything under the sun into this provision of terror. So I also say this because in a special law, when if everything is special, then nothing is special, right? So if everything is terror, then in a sense, nothing is terror. So the court here says, okay, so whatever the state's case is, this is a terror case. So that becomes one of the reasons why they don't look at the bail applications from that perspective. So now that they've decided, okay, this is a terror case, so automatically this Section 43, Zahur Ahmad Shah Watali, all of that applies and we have to tie our hands back.
And so tell us, what does this now mean for Umar and Sharjeel? Would they just have to wait for the trial to begin now?
So that is the other part, because the court says that given the severity of their offense, although they have spent, quote unquote, a substantial amount of time behind bars, they haven't crossed this so-called constitutional threshold. So, okay, so when do they cross it? Then because the gravity of their offenses are not changing, right? That's what the state is accusing them of. For some specious logic, the court says the threshold can be crossed after a year or after these protected witnesses are examined, whichever is earlier. Now, if your yardstick is gravity of offenses, then this timeline shouldn't come into place. If your yardstick is timeline, which means somehow after 1 year they've spent enough pre-trial detention, then you shouldn't be talking about gravity of offenses, right? But the court mixes up this logic and says, for now, the charges are so strong that we don't think they've spent enough time in jail. But after a year, they can again revisit, which is, say the protected witnesses will take a year at the least or even more for them to be examined. And after that, they can move the trial court and the ladder goes on. Then you go to the High Court and then you come to the Supreme Court.
And next, we turn to the case of Ankita Bhandari, a 19-year-old who was killed back in 2022. Ankita worked as a receptionist at the Vanantara resort in Rishikesh, and it was 7 months ago that the accused in the case were finally convicted. But now, fresh allegations have emerged linking the case to a senior BJP leader and which has triggered widespread protests across Uttarakhand. To understand what these latest allegations reveal, we spoke to the Indian Express's Aiswarya Raj, who began by taking us through how the case first unfolded.
So this case dates back to 2022 September, when Ankita Bhandari, a 19-year-old receptionist who was working at this resort called Vanantara in Rishikesh, she was killed by the manager of the resort, Pulkit Arya, who was a son of the BJP leader and former BJP state minister Vinod Arya. And this happened in September, and her body was recovered 6 days after she was killed, and she was pushed into a canal in Rishikesh. And after the body was recovered, there was like a big protest, a massive protest broke out from different parts of the state, and everyone was demanding that the accused be arrested. At the same time, there was also this allegation that a VIP was involved in the murder because she was allegedly asked to render sexual favors, and when she refused to do it, she was killed. So this was perpetually demanded by a senior BJP leader, but a name never came out back then. So that is what happened in 2022.
And Aishwarya, after the investigation took place, was the accused, that is Pulkit Arya, arrested? Tell us about him and what happened after the case unfolded.
So there were three accused, Pulkit Arya and his two aides, Saurabh Bhaskar as well as Ankit Gupta, and they were also arrested, and all three of them were convicted. Pulkit Arya was actually convicted for another section, that was sexual harassment. The other two were convicted under murder and sections of Immoral Trafficking Act. So there has always been this claim that she was asked to perform sexual favors, which when she refused to do, she was killed. So that has always been there. Even in the prosecution's case made out in the court, it was always spelled out. But as this claim has just now resurfaced, the SIT, which was formed to probe this case, one of the officers who was involved in the SIT has said that we probed into this allegation, but we could not find anyone. There was nothing credible tying the identity of a person to this VIP allegation. But even after that, a part of the society, civil society organizations had approached the High Court saying that there needs to be a probe into this specific angle that a VIP was involved so that there is no bias by the state machinery while probing. But the High Court was confident with the SIT's probe and they did not recommend a different probe or a CBI investigation into it. After that, the same organization went to the Supreme Court, and with the help of senior advocate Colin Gonsalves, they had gone to the Supreme Court, and there they filed an appeal. And even the Supreme Court last year in March, it dismissed the petition saying that the trial is underway. So even when there were allegations regarding the VIP's involvement, there was also the court's own statements or the court's own confidence with the probe and with the trial unfolding in the lower court, which hindered a different approach or different investigation into the whole angle.
And so, what is the reason that the case has now resurfaced? Why is it being talked about now?
So, in December 2025, a woman named Urmila Sanavar, who is purportedly married to former BJP MLA Suresh Rathore from Haridwar, she released a video in which she said that the VIP in question was senior BJP leader. And later she posted another audio recording which had allegedly been undertaken between Urmila Sanavar as well as her husband. In that, Rathore says that this VIP leader or VIP person was Dushyant Gautam, who is the National General Secretary of the BJP. And he's also the in charge of Uttarakhand BJP. And after that, there has been a widespread protest across the state, again demanding justice to Ankita Bhandari, because this was the first time a name has been spoken in the public, which is why everyone just got so viscerally angry at it, and everyone was just demanding justice. That justice has not been obtained because earlier they could not find a person who fit these definitions of a VIP. So now that they have a name, there has been a protest across the state.
And Aishwarya, the audio and the videos that were released by Urmila, how has Rathore reacted to them? What has he said about these claims?
So after Urmila uploaded these videos, Rathore, who is allegedly not with her anymore, they have separated, he came out, he held a press conference saying that it was an AI-generated audio, that I've never spoken like that. So he has denied being a part of the whole thing. But an SIT has been formed by the state, and it has asked the SIT to look into these allegations and to see the veracity, how veracious these claims are made in the audio. And just a disclaimer that these two people, Urmila Sanavar and Suresh Rathore, they are questionable because they have got multiple cases registered against them, especially Sanavar. She's got at least 10 cases registered against her, and her videos that she posts constantly on her Facebook and other social media platforms have been flagged several times. under sections of IT Act. So these are allegations, and at present there is no substance to back these allegations.
Right. And what do the people protesting have to say about the case, and what have they been demanding?
So it's been 3 years, and still we see that anger, this momentum, in the sustained momentum in the protest we have seen. It's really surprising. And I think one of the reasons is that there is this real and imagined fear that one thing, that immigrants are coming to the state, that there is a lot of jobs are being stolen by them, that they are setting up homes in the hills and they are taking away resources. And the state is also actively feeding to this narrative, as we can see from the past few years. At the same time, there's also this real fear that people have to send their children, have to send their family to other places, other states, as well as in the plains of Uttarakhand, to have a sole breadwinner to the family. Because even if we see Ankita's case, she was the only person working in the family, and even before she could draw her first salary, she was killed. So there is this precarity associated with unemployment, with underemployment, and these low income jobs that these people are supposed to take up to help their family sustain. So especially if we look at it as a larger picture, we can also see this pattern, especially when Goa fire happened. Out of the 25, 26 people who died, 5 people were from Uttarakhand. So that could explain the unemployment crisis unfolding in the hills. And especially when something like Ankita Bhandari case happens, and in a state which is known for the public participation of women in the public sphere, we can see that these fears are also not unfounded clearly. So people, when I spoke with them, they were speaking about how the hills have been hollowed out by migration and there is no one there, there is no real achievement to the people there, that everyone's leaving, there is no jobs, there is no resources, there is nothing to cling on to in the hills. And this anger directed at the government has been building up for so long, and this is an immediate cost to that.
And Aishwarya, has the Uttarakhand government responded to these protests and the concerns raised by the protesters?
So the CM conducted a press conference on Tuesday, and he actually suggested that there was a conspiracy because very recently in September we had another wave of protest in the state regarding the paper leak allegations in the UK SSC exam. So the CM said that these protests, or the pattern is unfolding intermittently. And he also said that he'll speak with the parents of Ankita Bhandari, and whatever they demand or whatever their opinion is, he would go ahead with it to obtain justice for her. So that is what he said. Other than that, there have also been statements from different ministers as well as BJP leaders denying most of these allegations. Also, I'd like to quickly add that the person who is accused of being the VIP, Dushyant Gautam, he has moved the Delhi High Court, filing a petition against Urmila Sanawar, Suresh Rathore, the Congress president of the state, Ganesh Godial, and a few others, and alleging that they have defamed him. So he has filed a defamation petition in the High Court. He has also filed a complaint which has been translated into an FIR in Dehradun against Urmila Rathore, as well as the Congress and the Aam Aadmi Party.
Right. So how do we see this case proceeding from here?
So the protesters, including the civil society as well as different opposition parties, they have been demanding that a CBI probe be recommended by the CM into this, so that they can see through the end of it. And still, so they have given an ultimatum to the government saying that by January 11th, if you can't come up with a resolution, we'll call a bandh, a strike. So right now, since the CM's press conference took place, and he did not specifically say anything about a CBI probe, but he said that he would speak with the parents. So we'll see what happens. But right now there is an SIT which is looking into the claims made by these two people, and also looking into the veracity of the multiple video clips as well as the audio clip that has resulted in these protests and these response from the people. And 4 FIRs have been registered against Suresh Rathore and Urmila Sanawar ever since these videos have gone public. And 2 of these FIRs have accused Suresh Rathore for trying to defame Gautam, because both of them are Dalit leaders, and he has been accused of trying to dominate over the same community that Gautam has got a good foothold on.
And in the end, we talk about the ongoing special intensive revision being conducted by the Election Commission. Nearly 6.56 crore voters, which comes to about 13% of the registered electorate, have been removed from the draft electoral rolls across 9 states and 3 union territories in the second round of the SIR. This marks a rise from the 8.3% deletions seen during the first round of the exercise in Bihar last year. With Uttar Pradesh having published its draft rolls, figures released by chief electoral officers across all 12 states and union territories show the total number of electors has dropped sharply from nearly 51 crore when the SIR was announced to 44.4 crore now. The Indian Express's Damini Nath, who has been reporting on the SIR, notes that in UP, where the draft roll was published after 3 postponements, the total number of electors decreased by nearly 19%. Of these deletions, over 14% were due to voters being marked as absent or having shifted. Around 1.6% were listed at multiple locations, and nearly 3% were recorded as deceased. UP's Chief Electoral Officer Navdeep Rinwa said that around 1.4 crore voters on the draft list have not yet completed the mapping process and will receive notices. These notices will specify the documents voters need to submit to be included in the final roll, which is scheduled to be published on the 6th of March. The second round of the SIR was announced last October for 12 states and union territories following the completion of the exercise in Bihar between June and September 2025. During the enumeration phase, booth-level officers fanned out to verify voters, marking them as absent, shifted, duplicated, or deceased where applicable. Damini also notes that the data from the states shows that most deletions were due to voters being marked absent or shifted. For example, UP recorded the highest such percentage among states, while Gujarat and Tamil Nadu also saw over 10% deletions under this category. The numbers could change further as the claims and objections process continues and the notices are issued asking voters to submit documents to prove eligibility. The SIR differs from the routine annual revision as it involves preparing electoral rolls afresh and requires voters to submit new forms and some asked to provide additional documents including proof of citizenship. The exercise has been challenged in the Supreme Court with opposition parties comparing the exercise to an NRC carried out through backdoor. The Election Commission, however, has said the revision was necessary after 2 decades of changes driven by migration, urbanization, and duplicate entries. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank Bhargav and me, Niharika Nanda. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.